at the same time, it does give us our first insight into how this test should be done. Yes. And our first insight into it is one where the court comes down against a more conservative court's strict interpretation of Bruen. And that's what Thomas got into in his dissent. Mm-hmm. I'm interested in your view as somebody who's has been critical of the Bruen test itself. Do you, like, Thomas has a pretty dark view of where this is going to lead for the Bruen test. He kind of is at least predicting that it could potentially undermine the whole concept and the Second Amendment generally. Now, I imagine you don't agree with his view on that part, but do you take his points about how wide-reaching the way the court came to this conclusion could be? That sort of combining surety laws and affray laws to make a principle when I guess his critique was that neither one of them was really good. Yeah. Like, what do you say? What do you think of the Thomas dissent?
Yeah. I think it's really interesting how forceful his dissent is about the majority's. I think he says that they try to rewrite the court's precedent. He certainly thinks that it is not like a different reading of Bruen, but in fact, like, if not a repudiation of Bruen, at least like a rewriting of Bruen. He thinks this isn't one kind of permissible style of implementing the Bruen test. And, I think I said something like this on Twitter earlier. I think his view of Bruen is a really narrow view of the test, but it also is basically the dominant view among lower courts, or it had been the dominant view among lower courts before the Supreme Court intervened in Rahimi. There had been some courts that had done kind of the principled stuff or raised up the level of generality a little bit, but lots of courts were reading the Bruen decision how Thomas read the Bruen decision, which is to say, we got to find a historical regulation. We're going to require the parties to put together a spreadsheet, right? Show us all the laws that existed between, maybe 1750 and 1805, right? If you compile that spreadsheet, I will pick out an individual law and I will compare that law to the modern law. This is what courts were actually doing in Second Amendment cases, based on this reading of Bruen that Thomas says, like, yes, that's what I meant when I wrote the Bruen decision. And the other justices say, that's not the right way. That's not the right way to read Bruen. So I think in terms of like Justice Thomas's dissent, he's right in the sense that that's the dominant way that other courts were understanding his test too. That's how I understood it when I was critiquing it. And the majority, I think, is maybe not reading my critiques, but reading the critiques of that reading of Bruen and saying, like, that can't be what we mean. It just doesn't make sense to say you have to have such a narrow comparison to a modern law, especially as the concurrences were fleshing out, because that's not what originalism requires when we're looking at the original scope of the right. In terms of Thomas's concern about the mixing and matching, I don't share his view that like that's, undermines like the Second Amendment if you can mix and match, because I think that the principles-based approach seems right if one is an originalist and thinks that history has to control contemporary adjudication. Then it has to be the case that we're looking not for a single particular law for all the reasons that Justice Barrett said and for all the reasons I've written about and others have written about. But we're looking for what was the original understanding of the scope of the Second Amendment at the time. That shouldn't turn on whether one particular law matches both the how and the why, right? Maybe you don't want to say like we can draw too many different kinds of laws together and pick principles and shove them together from too many different kinds of laws. But historical evidence that events is a principle is what we're looking for. And even the Bruen understanding of relevant similarity and these metrics, they're all trying to get at like what was the original understanding. And so I think he makes too much of focusing on like these two metrics that we gave, the how and the why, as themselves like the end point, as opposed to as themselves like a sign of what the original kind of scope of understanding was.
So when he says essentially that because of the way they, especially the affray laws, the going armed to the terror of the public laws, that because people could be imprisoned for that, that implies that their guns could be removed, at least temporarily.
Right.
That's sort of where the majority comes down on how they're relevantly similar. But he argues that, well, that's much too broad of a reading, because you could say anything that had a potential punishment of jail time, or like if you don't repay a fine, you end up in jail too.
Yeah.
So he sort of says this goes so broad that you could pick out any laws.
Yeah.
I imagine you don't agree with his critique on that.
Well, I think maybe that's one critique of the court's like discussion of the penalty, but the penalty was only one aspect of the majority's discussion of the comparability of the burden. They also talk about that it's time limited in nature. Like that's something would stand apart. Like the felon prohibitor is permanent, so that stands apart already. So it's not the case that just because you have going armed laws that justified imprisonment, that everything else is automatically justified, because the penalty is only one aspect of the burden. So they talk about the time limited. They talk about that the fact that it's an individualized determination, so it's not a categorical basis, like again distinguishing the felon prohibitor. So I just think that the majority had other reasons why it's comparable that were beyond just the fact that imprisonment was provided for in those historical laws and the modern law. So I don't think the roof is falling nature of Thomas's point on that particular provision is kind of persuasive.
And that does seem like what the other conservatives thought in response to Thomas's dissent. But it does sound like you perhaps agree with him to some point that the initial test appeared to me much stricter than how they've applied it in this case. Is that fair to say?
Yeah, I think I would say that there were a couple of ways to read Bruen when it came down, and judging by who the author was and what his expressed views in the Second Amendment are, many of us read it to say, well, that seems to require a really strict approach, a really narrow approach. A broader approach is consistent with what the court said in Bruen, but the narrowest approach was probably the best reading of what he meant, expressed in his own words in Rahimi. And so that's why a lot of people took the test to mean it's got to be strictly applied, and it's got to be narrow historical analogies. And so even folks who were argued within the Bruen framework weren't saying people would make arguments, right? Well, some will be, or most of them will be within the Bruen framework. So litigants were not asking the court to overrule Bruen. They were saying like there's this alternative reading of Bruen. And I think that's what the majority was adopting, an alternative reading of Bruen that, I think at the end of the day, we can debate how much that is a rewriting of Bruen and how much of it is just an alternative reading of Bruen. Right. If we, held their feet to the fire, what would, the Chief Justice or Justice Alito, who signed on to Bruen, say about whether or not it's a rewriting or a, alternative reading of Bruen? At the end of the day, it doesn't matter, right? But I think it's an interesting point to debate whether or not, this is a repudiation or rewriting of Bruen or just an adoption of an alternative reading of Bruen. But I do think it's the case that Thomas is right about what the dominant interpretation of his opinion was before Rahimi.